Good afternoon, everyone. It is my pleasure to welcome you to the webinar of the Heinrich-Böll-Stiftung called No Carte Blanche for Orbán, European Parliament Takes Commission to Court. My name is Adela Jurečková. I'm the director of the Heinrich-Böll-Stiftung Prague. We are a green German political foundation, and our Prague office works in Czech Republic, Slovakia, and Hungary. We are hosting this event together with our office in Brussels, so welcome also on their behalf. From Prague and Brussels, we at HBS are following and analyzing the steadily worsening situation around rule of law in Hungary. We have, of course, also closely followed how the European Commission tried to enforce the restoration of rule of law there by freezing funds, how the Hungarian government reacted to it, and then how the Commission released parts of the freezed funds just a day before the very important vote on key agreements on Ukraine, that Viktor Orbán has threatened to block. And this indeed curious timing provoked many doubts, and the decision of the European Parliament to take the Commission to court actually for this is maybe still something that many have not foreseen, and that it's rare but not completely unprecedented. And this is a novel situation, I think there is a lot to discuss about the backgrounds and about the impacts of this lawsuit. And therefore, I'm very happy that such distinguished experts have accepted our invitation to this webinar. Let me first introduce them briefly. Loran Pesch is Professor of Law, Dean of Law, and Head of the Sutherland School of Law. He is also a visiting professor at the Bordeaux University. He specializes in EU public law and has lectured in a variety of subjects, including EU constitutional law, EU internal market law, or European human rights law. As co-director of the organization The Good Lobby Profs, which he co-founded in 2021, and also member of advisory boards of several human rights organizations, his engagement around the rule of law reaches far beyond the field of academic research. Welcome, Loran. Marta Pardavi is an experienced civil society leader and human rights advocate. She is the co-chair of the Hungarian Helsinki Committee, a Budapest-based leading human rights non-governmental organization that protects human rights and the rule of law through legal and advocacy methods with a focus on civil space, rule of law, refugee protection, and criminal justice. And she also holds a law degree. Welcome, Marta. And last but not least, Kim Lane-Schäppele is Professor of Sociology and International Affairs in the Princeton School of Public and International Affairs and at the University Center for Human Values at Princeton University. She is also a faculty fellow at the University of Pennsylvania Law School. Her primary field is in the sociology of law, and she specializes in ethnographic and archival research on courts and public institutions, but also on human rights and the rule of law in the EU. So before I will give each of our speakers the floor for short opening statements, I would like first to make a few practical remarks for our audience. First, we will have time until 2 p.m. And after the opening statements, there will be some time dedicated to discussion. You as the audience can also participate in the discussion via the Q&A tool that you can see below the speakers in Zoom. You can write down your questions there anytime, but please understand that I will get to the questions only at the end, which means the last 15 to 20 minutes. You also have the possibility to upvote some questions that were asked by other participants, so make use of it. And last remark, please note that the webinar will be recorded. So we have a lot to discuss and not as much time, so I would like to jump right into the introductory remarks, starting with Kim Lane-Schäppele. Kim, please give us an insight into the landscape of the different funding freezes and unfreezes the Commission has resorted to in case of Hungary, and also in the rationale behind it. The floor is yours.
Great, thank you so much. And I think what I would like to do is to give a kind of background so that people who are new to the subject can figure out exactly what got frozen and what got unfrozen. And so I'm going to share my screen and just go through some slides very quickly. If anyone would like to have the slides because they're going to go by fast, let me know and I can send them, or the folks in Prague can send them as well. So first of all, the idea of freezing funds to rogue member states is something that is actually relatively new. It started with this budget cycle, and as the EU began its budget cycle for 2021 to 2027, the Commission floated this idea of a conditionality regulation that would make the receipt of EU funds conditional on honoring the basic values of the EU. And so the focus, I think, for much of this budget process was on this thing called the conditionality regulation, which passed finally in December 2020. And as it went through the process, it got battered and it got watered down. And in the end, what it allows is for the EU to withhold funds, all funds actually are covered by this, to any member state, and this is almost a literal quote, this is a literal quote from the regulation, where that state's rule of law problems has interfered with the sound financial management of the union budget or the protection of the financial interests of the union in a sufficiently direct way. So this became more or less a kind of anti-corruption program when it started as something much broader. You have to demonstrate a link to the budget to be able to freeze funds under this. But as it turns out, there were a whole package of laws going through with the budget, and the conditionality regulation also had some company. So as many of you will remember, the budget was divided into two pieces, the regular multi-annual financial framework, and then this Recovery and Resilience Fund. And in the regulation for the Recovery and Resilience Fund, it turns out there was a separate conditionality that got added there. In fact, while many of us were not looking. So what was the regulation? What was the conditionality there? It allows EU funds to be frozen for violations of the, quote, country-specific recommendations. Now, everybody familiar with EU speak will know that country-specific recommendations have generally been interpreted to be the sort of macroeconomic recommendations that come with the European semester, something started as a result of the financial crisis a decade and a half ago. But it turns out that the Commission, since 2019, had been adding sort of rule of law related conditionalities to those macroeconomic recommendations, particularly with regard to judicial independence for Hungary and Poland, and also anti-corruption measures for Hungary. So suddenly, this conditionality also allowed freezing of funds for rule of law related issues. And that was not alone. There was actually a third thing that happened as this package of laws related to the budget all went through this long process. The Common Provisions Regulation, a regulation which only an accountant could love because it's hundreds of pages of detailed accounting standards, the Common Provisions Regulation was also changed to add this clause in Article 9, which allows funds to be withheld if the member state violates the Charter of Fundamental Rights while spending EU funds. So what this meant was that there were three different streams, or three different legal bases and three different legal regulations under which EU funds could be frozen to a member state. Excuse me. Now, what differed among them was not just the legal basis and exactly, why the funds could be frozen, but also the procedure. And you see in the second row here that both the conditionality regulation and the recovery and resistance regulation start with a recommendation from the Commission that must be approved in a QMV decision of the Council. And that's also true for when funds are unfrozen. Commission recommends, the Council must unfreeze by a QMV recommendation, by QMV decision. The Common Provisions Regulation conditionality, however, is different because that one is assessed and implemented solely by the Commission and may also be ended solely by the Commission. And that's going to be the one that we're going to really be talking about today. And you'll notice that the regulations apply to different streams of funding, while the conditionality regulation applies to all funding, The Recovery and Resilience Regulation only applies to those funds, and the Common Provision Regulation applies to everything that goes into what's called the Partnership Agreement, which is about 12 different sources of funding, particularly the cohesion funds. Okay, now with that structure in place, in December of 2022, the EU decided to freeze a lot of funds to both Hungary and Poland, and it happened in this December sort of flurry of activity. The EU withheld, so far as we can tell, about 137 billion from Poland because of lack of judicial independence primarily, but also violations of gender equality and LGBTIQ rights. Sorry, I always stumble. But the Polish funds were withheld under two of these sources. So the recovery funds were withheld under the recovery regulation. The partnership agreement, meaning the CPR withholding, was done under a separate authorization. With regard to Hungary, where 36 billion were withheld, and by the way, less funds were withheld from Hungary because they simply get less funds, being a smaller country, doesn't mean the offenses were less serious. These funds were withheld under all three of these authorizations. So the conditionality regulation cut some of the funds, the recovery regulation cut others, and the common provision regulation by far was the biggest source of funding freezes. And then a year later, the Commission decides to start unfreezing the funds, okay? And this sort of tells you what's in red is where the funds were withheld. So the conditionality regulation funds are still withheld. The recovery and resilience funds with regard to Hungary are still withheld. Both of those would have to pass back through the Council, and the Commission hasn't suggested that. What the Commission has done, and this is the object of the lawsuit, is that the Commission decided to unfreeze some of these funds that had been frozen under the Common Provisions Regulation, where the Commission had the discretion to both freeze and unfreeze funds. And that's where the 10.2 billion that were unlocked in December 2023 came from. And that was when the Commission decided, on the basis of a very cursory review, that Hungary's judicial reform efforts had managed to actually establish a positive change. Just for comparison, we might add that the Commission just a month ago decided to unblock all the funds for Poland, even though the new government is trying, but has not yet succeeded in changing very much with regard to judicial independence. And there, the Commission just made the discretionary decision to unblock all the funds that were withheld under the Common Provisions Regulation, and now has proposed to the Council to do the QMV vote to unblock all the recovery and resilience funds. So that's where we are on freezing. And so this leads to the scandal that Adela mentioned at the very beginning. When these funds were unblocked to Hungary in December 2023, it happened literally 2 days before a UCO summit at which Hungary was threatening to block two files that required unanimity. One was the vote on EU accession for Ukraine. The other was the vote on funding for Ukraine and a modification of the EU budget. And so Orbán is given this money. He agrees to leave the room when the accession vote happens for Ukraine. He then comes back and vetoes the budget. So in other words, the 10.2 billion didn't buy them as much as they thought. And what we've since realized is that, of course, the Commission's decision to unfreeze the funds was completely cursory and did not really take into account that the reforms that they had claimed were the basis of the unfreezing had not yet actually really been put into practice. And so now, and this is what brings us here, the Parliament has made the decision to take the Commission to court with this fundamental question. Did the Commission abuse its discretion in releasing funds to Hungary under the CPR? Because the other two funds have a check from the Council, but this is the one that the Commission unblocks or blocks all by itself. And that's where we are, and it's not the end. Thank you.
Thank you as well. It's definitely not the end. And it was very insightful to see the different conditions for freezes and unfreezes and to understand better what we are actually talking about when it comes to this lawsuit. And what plays an important role here is, of course, also what did actually the Hungarian government do in order to fulfill what the Commission wanted them to do in order to unfreeze the funds. So that will be for the European Court of Justice an important thing to decide on as well. So Mata Padavi, I'm turning to you because you have been monitoring the rule of law in Hungary since many years. You have analyzed the implementation of the reforms that were a condition for releasing these funds for Hungary. And I would simply ask if you think that these reforms were sufficient, or would you rather support what the parliament claims, meaning that the release of fund was unlawful because the only thing that the Hungarian government did was cosmetic changes, basically. Give us your assessment.
Thank you, Adela, and thank you for organizing the webinar on this important subject. I am very conscious of what is at stake now before I give you a full answer to your question, because we really have to remind ourselves, and this is where Kim also left off, that there is 10 billion euros at stake in the case of Hungary. This is how much funds have been unfrozen, and this is what the European Parliament, I think, is challenging, whether it was the right to unfreeze 10 billion euros. That is an excessively big amount of money. And this is, of course, an important source for the Hungarian national budget. And in a way, what is also at stake is the trust in the process of tying European funds to rule of law standards. The future of this tool is actually at stake. So Kim has already mentioned that judicial reforms, ensuring the independence of the judiciary, were just one very important part of the many conditions that relate to why funds to Hungary have been blocked, frozen. And these judicial reforms are, of course, fundamental. And to give you an idea of what they are about, there were very concrete achievable outcomes that the Hungarian government and the European Commission have agreed to at the beginning of this process. And these concerned four main fields: to strengthen the judges' independent, self-organizing unit called the National Judicial Council and its independence, to give it more powers and to make it more independent; to strengthen the judicial independence of the Curia, which is the Hungarian Supreme Court, to make sure that it is less prone to political influence and interference. Third, it was to remove the obstacles that make it difficult for Hungarian judges to turn to the Court of Justice of the European Union. And also the fourth was to remove the possibility for public authorities to challenge final judgments at the Hungarian Constitutional Court. So basically, while these sound technical, but their purpose was to heal the persisting concerns that relate to the independence of the Hungarian judiciary. And it's very logical, I think, to say that if these super milestones are not complied with, or if their non-compliance is overlooked, then these serious rule of law problems will continue to persist. And therefore, the whole exercise will not yield the expected results. And so over many, many months, a small team of civil society experts in Hungary have been investing really hundreds of hours and producing hundreds of pages to track progress with these milestones on how Hungary is coming along in implementing and complying with them. And these analyses have shown that there were, with the judicial reform, steps taken in the right direction. And this judicial reform package was indeed aimed at giving life to the super milestones, to safeguarding judicial independence. But we also had to conclude, after all this analysis and doing this all the time throughout the process up till today and beyond, that out of these four judicial super milestones, 3 have been implemented defectively. So when we look at how these super milestones have been implemented in Hungarian law, it becomes very clear that they fall short of expectations. And we, in fact, detected a genuine lack of commitment on the part of the Hungarian government to reverse the course of rule of law backsliding. Even today, in some aspects, the needed changes have not been made, or it's too early to tell if these changes are being applied in a manner that is both effective and sustainable. And altogether, all through these years, of course, it's often said that Hungary's government had been following a very technical, super legalistic, very sophisticated approach on its path to dismantle rule of law protection over the past 14 years. And now this technical approach has been deployed to conceal what we termed were tricks, meant to avoid full, effective, and sustained compliance with the milestones. And this is especially the case when the reforms could result in painful consequences for the political ruling majority. So as I said, these compliance deficiencies that persist might seem technical in nature, especially in light of the large judicial reform package, but details do matter. And the fact of these shortcomings is, in our view, fundamental. So let me give you just 3 brief examples of tricks that show how the compliance shortcomings are fundamental in their effects. The first trick was when laws are changed, but the problem remains. So, for example, in the endeavor to depoliticize the election of the Curia president and to avoid the possibility of cementing the highest judicial office holder at the will of the ruling party in position, there was a change, but this change now means that the new president of the Curia can only be elected by a 2/3 majority of the Hungarian parliament. And until this majority is formed, a blocking 1/3 minority can keep the current office holder in place in office. And since there is no retirement age for the highest office holder in the Hungarian judiciary, the person can stay indefinitely as long as a blocking minority is sustained. Or another example is where there is laws, but there are transitional provisions that would be needed to highlight how these changes take effect are missing. Trick 2 is to say one thing, but do something else. And this was, for example, with regard to the obstacle that has limited Hungarian judges to turn to the Court of Justice of the European Union when they are asking the court to interpret EU rules, EU laws. It was a legal change that was enacted, but still an internal but very important precedential decision of the Curia remains in place. And so it continues to exert a chilling effect on Hungarian judges. This chilling effect, which is so key in all rule of law backsliding questions and as regards Hungary, this chilling effect on judges has not been effectively removed. The third trick is to comply, but only on paper. So this is when compliance under legislation has been done because legislation has been adopted, but it's not fully implemented. And for example, this is what concerns the transparency of the case allocation system at Hungary's highest court. A case allocation system should be an automated process without real human interference to ensure that there is no potential human interference on political grounds, for example, and to ensure that everybody has the right to a tribunal, a panel of judges that is established by law and not by arbitrary whim of senior judicial leaders. Now, a new case allocation system has been implemented, but this is half-hearted, and even Hungary's Supreme Court, the Curia itself, could not provide proof of the existence of a fully compliant IT system. Now, looking forward, knowing that some of these decisions that are affected by the case allocation scheme's shortcomings will concern election issues, there is, of course, a risk to the fairness of EU elections because we don't know exactly which judges will be carrying out post-election adjudication. These super milestones that I've talked about are very important, but perhaps there is, as a last thought, something more broad about the charter itself that EU funds are meant to further and protect. And I think it's important to say now, as we zoom out, that the judicial super milestones are just one part of a much larger set of concerns that also impact on how the Charter of Fundamental Rights in Hungary is respected. And so in our assessment of whether the charter is being complied with, of course, it's important to take into account of the context. Much of this is very well documented. There is ample evidence, and some of this is new. Since 2018, the Article 7 process has been ongoing. There are many judgments, several judgments of the Court of Justice that have not been fully implemented by Hungary. State of danger, a form of extraordinary legal regime, is in place for now over 4 years, and over 1,000 decrees have been adopted, setting aside or ignoring the legislation in place. Civic space, media freedom continues to be under threat. In fact, the latest, the sovereignty protection law, prompted the European Commission to launch an infringement process just recently. And this infringement action referenced the principle of democracy and the Charter of Fundamental Rights, which is at stake. And so as we think about what will happen with the 10 billion euros and with the future of this tool, I think we have to be very, very mindful of this reality. And this will be something that the courts of justice will rule on if the lawsuit goes forward. But what is equally important is to maintain this trust in this instrument, if it is going to be used ever again. And the legal standards and the legal assessment will have to focus both on the details, on what is happening in practice, and also on the broader picture that we're living in. Thank you very much.
Thank you very much, Marta, for this insight in the compliance of the reforms with the milestones, and thank you for the important work you are doing there. And that helps a lot, I think, not only the EU institutions to assess the reality of law, the rule of law in Hungary. And I agree that this is a much bigger and much broader problem, not only focused on the current lawsuit and its target, but we will come to that later. Thanks for now, and I would like to close the introductory round by giving the floor to our third guest, Loran Pesch, to give us a little outlook for the current lawsuit and share with us what it actually means practically for the EU, especially for the institutions that are involved, the Parliament, the Commission, and the European Court of Justice, and what can we expect to happen in the upcoming weeks and months within this legal battle.
So thank you very much. I'm going to focus on the Commission's line of defense in this litigation. But before I get to the Commission's main argument to justify the unlocking, I think it's important to step back from this particular specific litigation and to take into account the broader context. And the broader context is about the politicization of rule of law assessment and rule of law enforcement. So this is a key background to understand what's happening. Now, I'm not suggesting that the Commission, as a guardian of the treaty, whenever it is actually using rule of law instruments, is not using it, is using them for political reasons. In fact, every time the Commission does act, my main problem with the Commission, it doesn't act enough. Every time the Commission does act, then the legal case for action is compelling. So here, in this dimension, the Commission is doing the job. So every single infringement action, not enough of them, but every single infringement action initiated by the Commission, is the legal case for doing so is overwhelming. Now, my main beef, so to speak, with the Commission is rather when the Commission is refusing to act and then it does so for political reasons or reasons of political expediency. In this case, it was not a refusal to act, but rather a refusal to stay the course after having blocked the funding for the right legal reasons. And the Commission has unlocked the funding and has been defending itself on legal grounds, even though I would say most of us would argue that the unlocking has been done for political or geopolitical reasons. Now, this is part of the broader context I was alluding to of increasing politicization pattern. And what is interesting is that not simply the European Parliament has been critical of this politicization pattern, but most recently, for the very first time, the Court of Auditors has essentially criticized the Commission along the same line. So there was a report actually on the rule of law conditionality regulation from, I think, last month. And in the press release, there was an interesting statement, and I'm going to cite it. Although decisions not to block or to release EU funds should be based on technical and legal analysis, political considerations may ultimately play a major role. And what was striking is that there was at least one member of the Court of Auditors who, in a newspaper article, was cited as saying that this is exactly what happened last December in respect of Hungary. So essentially, even though the Court of Auditors, the report itself is kind of written in a diplomatic language, even the Court of Auditors is worried about the politicization of rule of law assessment and rule of law enforcement. So it's not simply the European Parliament now being very critical, but another key major EU institution, the EU Court of Auditors. Now, where it gets interesting from a legal point of view is that the Commission is, of course, denying that political considerations have played a role in the decision to unlock EU funding. However, there are many aspects which makes this defense or line of reasoning very unconvincing. So I'm just going to mention a few key aspects because my time is limited. First aspect, in October, actually, well ahead of what happened in December, there were newspaper articles already announcing what would happen in December. And there was a very interesting article, I think, in Politico, where there was an anonymous EU official saying that funding would be unlocked at the moment of maximum leverage in December in the context of Ukraine. So this is circumstantial evidence, but quite clearly the deal of December was already pre-cooked or was being pre-cooked in September, October. Second aspect, the Commission's rush to unlock funding just at the time of the European Council summit. Now, my understanding is that the Commission received clarifications from the Hungarian government the very same day he adopted the decision to unlock funding. I mean, how can you seriously argue that you have fully assessed the correspondence you have received from the Hungarian government on the very same day that the assessment is already out? I mean, any lawyer would tell you that's just not possible. This is just, you need a significant turnaround time in order to assess whatever legal documents are submitted to you by the party you're working with. So the rush to unlock funding, I mean, time-wise, this is very suspicious. And the Commission also is arguing that he had a legal obligation to act on the very day he adopted the decision, but that's not legally true. So, I mean, I suppose they can make this, they can debate this point before the Court of Justice. But they had more time to actually unlock funding, unlike what the Commission has officially claimed. Third aspect, the Commission's assessment is in fact not an assessment at all. If you look at what the document called assessment, in fact, it's just a descriptive outline of the legal changes which have been adopted by Hungarian authority. I would say I haven't counted every single sentence which looks like an assessment, but I would say maybe you have 10 sentences which can be arguably be described as assessing some aspects of the adopted changes. So there is no meaningful assessment. And in fact, I could argue, legally speaking, you could argue, there is no legal reasoning whatsoever. There is the duty to justify the reasons, which is a legally binding principle, has not been satisfied by the Commission. I'm sure that's an argument the European Parliament is going to make. What is also interesting in this context is that the assessment decision itself does, in fact, confirm the criticism of the Court of Auditors the Court of Auditors criticized the Commission for just undertaking a tick boxing exercise whenever assessing changes, not reforms, please, just changes adopted by Hungarian authorities. The tick boxing exercise as well, I mean, then you can argue plenty of manifest errors of assessment by the Commission, because the Commission is simply ignoring all the evidence regarding lack of implementation, regarding a violation of the recovery milestone, regarding inclusive and normal lawmaking processes. So essentially, the assessment is not simply a tick boxing exercise, but it's a selective tick boxing exercise. The Commission also ignored the adoption of the sovereignty authority law, which yesterday the Venice Commission recommended to repeal. So that's another aspect. And just speaking of this sovereignty authority, I mean, there is nothing preventing this new authority for going after a judge submitting a preliminary ruling question regarding corruption or rule of law matters falling within the scope of EU law. Then that's another area where essentially the Commission has ignored the chilling effect, actually, of the very establishment of this authority. Fourth aspect, the Commission is contradicting itself by blocking funding under the conditionality regulation on the basis that there are remaining persistent systemic risk regarding corruption. So, I mean, how can you unblock EU funding on the basis of partial compliance and then refuse to block funding under a different instrument on the basis that there is a lack of full compliance? So there is a lack of consistency here. I would say even you could argue this is an instance of irrational decision-making process by the Commission on this basis. But it gets worse. Fifth aspect. The official line of the Commission, at least as reported in the newspapers, is that the Commission, according to the Commission, what I've read is that the Commission is arguing that the Commission was under a strict legal obligation to unlock funding. So they're not arguing that they have exercised their normal discretion here. They're arguing that they had in fact no discretion. Now, this is, I would say, perhaps unwise as a line of defense. We'll see whether they're going to submit the same line of reasoning in their legal submissions to the Court of Justice, but either you have discretion or you don't. So the Commission will have to choose. I would argue that the safest legal argument they can use is that, in fact, in this area, there should be given wide discretion when it comes to assessing the rule of law situation in an EU member state, whether it complies or not comply with their own milestones or requirements. The problem here, I would say, is that there is evidence that the Commission has abused its discretion, its legal discretion for political reasons. I think the European Parliament is going to try to get its hands on correspondence between the Commission and the Hungarian government. The Commission has refused to disclose this correspondence to date. Another problem is that with the passage of time, while this litigation is pending, then everyone is going to come to the realization that all of these changes are Potemkin-like changes. Nothing is going to change. I expect, in fact, the situation to get worse, not better. Then it would make the Commission's assessment of last December even more laughable than it was then. And another, I think, problem for the Commission from a legal point of view, the Court of Justice is very unlikely to accept the argument that the Commission should be given wide discretion to assess compliance or not compliance with EU rule of law requirements, considering the now very solid body of case law we have seen originating from the Luxembourg Court. Marta was mentioning the functioning of the preliminary ruling mechanism. The Court of Justice is unlikely to show any patience when it comes to the continuing undermining of the preliminary ruling procedure in Hungary. In addition to this new sovereignty authority, I mean, still, if you look at the Hungarian constitution, I speak subject to the control of Marta and Kim, there are areas where technically a judge is not allowed to refer questions to the Court of Justice on the basis of the Hungarian constitutional identity. There is kind of a constitutional identity clause which could be used actually by this new sovereignty authority to go after judges. I mean, why not? So my point is essentially that the EP has a strong case. Then they're most likely going to argue multiple manifest errors of appreciation. And they're going to argue most likely also failure to state reasons. And I would say third, the EP should argue misuse of powers. This is more difficult to substantiate. But I think clearly here we have the Commission has acted as a political commission and not as the guardian of the treaties. And I, for one, welcome this annulment action. Thank you.
Okay, thank you very much. We don't have a crystal ball, but like as you said, the EP has a strong case here, and you've provided, and Marta also has provided several legal and factual arguments why the European Court of Justice could actually rule in favor of the European Parliament. Let's see also how the Commission will defend itself, and how long this will take. This we might also maybe discuss later. But maybe before we do that, and before we also get to some questions from the audience, I would like to give Kim the chance to maybe, or I would like to open a broader topic about it, like not only this lawsuit, because we were always also referring to this being a bigger problem and a broader issue. So Kim, how do you think that this lawsuit could actually impact the future of the rule of law assessment and enforcement in the EU, which, as we heard, is at stake, and in general, maybe the defense of liberal democratic values in the EU? Because if if the lawsuit is successful, maybe, but that again, I would leave up to your assessment, we can hope for preventing further backsliding, this serving as a precedent. And on the other hand, if it fails, could we maybe expect that this will be a signal to also other illiberal leaders that there is not so much to be afraid of, and they will anyway get away with some cosmetic or Potemkin-like changes? Thank you.
Yeah, thank you. Well, this is, of course, the worry, which is that, the Commission freezes and unfreezes funds depending on what it thinks about the political developments in the country, rather than what it thinks about the actual legal framework for protecting the rule of law. And I think what this whole episode over the last 14 years of the Hungarian descent into autocracy, followed by the Poland, near miss of the same, is that the Commission, as it became a more political commission, gave up on law enforcement, gave up on enforcing EU law. This has been well demonstrated in some of the work of our colleagues, Dan Kellerman and Tom Pavone, where they show that infringement actions by the Commission were down 80% since the Barroso Commission, for example. So this is in the context of a broader picture in which the Commission has two different functions that it can't seem to manage simultaneously. One is initiating a lot of new proposals and getting member states on board and sort of cajoling them into cooperation. And the other is actually enforcing EU law. And so they've been trading one off against the other, trying to get their proposals through by compromising on the rule of law. And that has really led to a complete mess. So I think, what we're seeing, if we look back on this moment from 10 years from now, this will be the beginning of a serious discussion in which those two functions of the Commission may need to be separated. And that was sort of the point of the Court of Auditors report. I stuck, by the way, the Court of Auditors report, the Venice Commission report, and the Commission's assessment of Hungary's reform in the chat. For those of you on Zoom, you can get to the links to the original documents. And what you see is that the Commission has absolutely no standards for being able to assess whether reforms have really been carried out or not. And much of that is because, everything that Marta said, and actually Marta's group together with there's a consortium of NGOs that wrote terrific reports, which I'll also stick in the chat, showing exactly why the judicial reforms and other reforms had really not made a practical difference yet. And yet the Commission relies on statements from the government. We passed the law, everything's fine. The Commission says they passed the law, everything's fine. That can't be the way enforcement is done. So, in the bigger picture, what this suggests is that we need a different system for enforcing EU law than to put it in the hands of the very Commission that's trying to cajole member states into working on common programs.
Yeah, thank you very much. I would actually like to hear what Marta's assessment on this as well, but maybe we can combine it already with the questions from the audience. Otherwise, we won't have enough time to address them. And there is one at the moment by Christophe Hillian. And the question goes, should the EP also sue the Commission for releasing EU funds too quickly to the Polish authorities? For example, before the conditions are fulfilled. So maybe in your replies, could you maybe extend it to Poland and the situation there? Kim already did partly, but so you can react to this, and then maybe Marta could comment on what Kim said, and maybe also the comparison to the situation in Poland.
And just a bit of context as well. Actually, the Commission is already being sued regarding the recovery rule of law milestones in respect of Poland, alongside the Council by Association of Judges, and have been playing a part in this litigation, just for full disclosure. The Commission is also has been sued most recently in respect of Romania. So I think this has been less noticed, but again, I've been playing a part in this litigation. The Commission has decided to end the cooperation and verification mechanism in respect of Romania and Bulgaria. From my point of view, again, that's another example of the politicization of rule of law assessments. I believe that this decision was purely justified by reasons of political expediency. And yet the formal decision is only alluding to alleged judicial improvements, which actually nowhere exist if you go, if you look at this, the reality of the situation. In the case of Poland, I'm afraid we have another instance of politicization of the rule of law assessment. Now, in this case, I understand that the Commission would like to reward finally would like to reward those trying to restore the rule of law, which is no easy feat. The question was about whether the Parliament should sue on the ground that this is another instance of politicization. The European Parliament has already refused to consider an annulment action in this respect. At least that's my understanding. And that does raise another actually broader issue. If the EP does not want to sue the Commission, and the Commission has kind of has already obtained the complicity of the Council regarding how to assess the rule of law situation in a specific member state, then we are left with no one with legal standing to actually bring cases against the Commission and the Council when they politicize rule of law assessment and enforcement. So the EP sometimes itself is subject to political reasoning. And in the case of Poland, I think they have decided on political grounds not to bring a lawsuit against the Commission for unlocking recovery and charter funding. I would have a critical assessment myself. You have to be consistent. The problem in the case of Poland is that the rule of law milestones themselves were arguably defective. So to some extent, I would argue that the Polish government was asking to actually comply with a milestone which was not consistent with the case law. But even regarding the milestones where allegedly they're consistent with the Court of Justice case law, the Commission has made a mistake, I believe, possibly for the right reasons, but they have accepted that the new chamber of the Supreme Court is actually a lawful court. I would argue that it is not a court. And they have created a bad precedent in this respect, because it means that you can have a chamber within a Supreme Court, half of the members of which are what can be described as fake judges. And that's good enough from an EU law point of view. So I understand the short-term reasons for unlocking, political reasons for unlocking funding in respect of Polish authorities, but maybe in doing so, they have actually made the long-term situation even worse from a rule of law point of view, because essentially it means that they can unlock whatever, depending on the political priorities of the day. And in doing so, they're actually reinforcing the criticism we have seen coming from Orbán, saying that the rule of law is in fact a political tool being used by the Commission depending on their short-term priorities. So the Commission, what should the Commission have done? Should have adopted the principal stance and should have stuck to the principal stance for years. Instead, we have a kind of a headless chicken type of enforcement, and they decide essentially they don't think ahead, and even when they lack consistency, it doesn't matter to them because their priority is the next 24 hours or the next month or the next 6 months. But we reached a stage where essentially now the Commission is contradicting itself in a number of instances. And we'll see in the Polish litigation case how the Commission is going to be able to actually defend this lack of consistency. It's going to be interesting. Sorry for the long answer. It's also going to be interesting to see how the Court of Justice is going to react. But at least with this EP legal action, legal standing is not an issue. So at least we'll get hopefully a judgment, assuming that the EP does not withdraw its action later. We'll get finally at last the court's assessment of the exercise of political discretion in this case.
Okay. Yeah, indeed, it will be very interesting what will happen, and we'll be following it. There was a quite interesting question by András Lukács in the chat, and he asks, if it is highly probable that the European Court of Justice will rule in favor of the EP, then the Commission is taking a huge risk. What could the Commission do if it turns out that it has spent public money illegally? And Kim has already replied that the Commission can either claw back funds given to Hungary, or it can withhold future funding streams in the amount of the misspent funds. And of course, also that EU institutions are still withholding a lot of money, around 26 billion for Hungary. This brings me to a question that is targeted to Marta, and I wanted to give her the floor anyway. And this is, when this would happen, actually, like what impact might it have on the situation in Hungary, like on the state of the rule of law? Do you think the government would be willing to do real reforms, or would it already the fact that the money would be missing have also some political impacts on the stability of the government, for example, or any other aspects that you might have in mind?
So I can say that this money is needed. So every single euro cent that is not accessible to Hungarian society is missing. And it is missing because it is an important source of revenue for Hungary, for the national budget. And so I think every single Hungarian is invested and interested in getting this money. The question is, at what price? From our point of view, the reason why we have invested all this time, and we will continue to invest all this time in monitoring and tracking, is because we think it's important to invest in the rule of law. And because that actually is good for citizens, for society, for democracy. Now, the divestment from these standards is what the Hungarian government has been doing, because the rule of law standards are, from a political perspective, extremely annoying. They are shackles. They stand as obstacles before takeovers of economy, of judges, of the cultural space. In fact, the rule of law is an obstacle to autocracy. And so it is, I think, quite worth our while to do this, and quite worth our while to, in this sense, fight for these euro cents so that they would serve Hungarians and the welfare and the well-being and the democracy of Hungarian society. But I have to say that if this continues, and might happen to other EU member states too, we have to be cognizant that there is really no support for this kind of social investment from citizens and civil society, so that this whole exercise up till today and also beyond will, I think, show that what we didn't know was how tedious this work is to monitor what is happening. And of course, geopolitical and political considerations will always be around, but we also have to know that it takes a lot of time, a lot of hours, a lot of people to actually understand what is going on and to draw conclusions which will have some impact. And I think for Europe as a whole, we have to see how we have underinvested both in our rule of law and democracy. And there is now, of course, a lot of discussion about how to undo this or how to strengthen. But we also have to invest in the capacity of civil society and also of lawyers and the commission and that of journalists, absolutely, so that people will understand what is at stake, so that it's not only the 10 billion or the 30 or the many more, but that the democracy, their security, their rights are at stake. And this is why we have to make this investment. So I think this is an important point going forward. When it comes to the next EU Commission, not only do I hope that they will take this task seriously, but that the sufficient investment of resources of stamina will be put into the process as well.
Thank you so much, Marta. I think we could go on for at least another hour, and yeah, there are so many aspects to it to continue discussing. But seeing the time running out, I unfortunately have to close this discussion. And thank you for this very insightful discussion that went very much beyond the usual media coverage of the case and the case itself, but it was also about rule of law and how to defend it in the EU and what is the efficient measures. So thank you very much for that, for all your insights. I think now we can only more or less patiently wait for the decision of the European Court of Justice and follow this case and what impacts it will have. Thanks to Kim-Lane Chapele, Marta Badawi, and Loran Pesch for bringing more light into the situation. Thanks to the audience for your good questions. And I think maybe in future we will have to meet again and continue this discussion. And for further analysis on political developments in Hungary and the EU, please check out the websites and events of Heinrich-Böll-Stiftung, Prague and Brussels, and follow us and our distinguished speakers on social media. There will be a little survey as well, so please stay in the room and yeah, it's already visible. So we would be happy if you could participate. That's it for today. Have a great day. Thank you a lot and see you hopefully soon at some other event. Have a nice rest of the day. Goodbye.